Good morning, good afternoon, or good evening, depending on where you are in this side event at the United Nations General Assembly. My name is Thomas Wuchty. I'm the Executive Secretary of the International Institute for Justice and the Rule of Law here in Malta, or the IIJ as we are known. I'd like to express my thanks for everybody joining us here today for this United Nations General Assembly side event, Battlefield Evidence and Criminal Justice Approaches to Counterterrorism, which is our second side event, as we did one last week at the UN General Assembly as well. We're very excited to have this follow-on event today. I'd like to thank in advance our distinguished speakers who I look forward to hearing from, all the people who have joined us around the world virtually, and deep appreciation to the United States Department of State Bureau of Counterterrorism for supporting and sponsoring this event. The topic of today's workshop, Battlefield Evidence, is both timely and important. It's an issue which we have worked on now for several years. The most effective way to respond to the security threat posed by foreign terrorist fighters and those providing material support is often prosecution or other criminal justice sector action. Information and material collected or obtained by military forces can be critical to investigating, prosecuting, and securing convictions of these terrorists in a manner compliant with rule of law and human rights, which is an essential part of the work of the IIJ and the other speakers today. At the same time, successful use of battlefield evidence poses a number of challenges, including collection, exploitation, and interagency coordination. The United States, through an interagency initiative of the Departments of Defense, Justice, and State, developed a set of 14 non-binding principles on the use of battlefield evidence in civilian criminal proceedings that provide guidance on how countries can meet these challenges, and the IIJ, through a series of workshops and a high-level senior leaders seminar, which was very successful in the end of 2019, has been supporting operationalization of the guiding principles, and also in coordination with the United Nations, which itself has issued a set of military evidence guidelines, which are a valuable and complementary resource in this area. I'm pleased to have two UN speakers with us here today, among our other speakers. Now, we have a very busy agenda, so without further ado, I'd like to introduce our other opening speaker, Mr. Christopher Landberg, Acting Principal Deputy Coordinator of Counterterrorism for the U.S. Department of State. He is a career member of the Senior Foreign Service, who prior to his current role served as the Deputy Coordinator for Crisis Response and Technical Policy. He came to the Bureau of Counterterrorism from Embassy Bogota, where he served as Director of the State Department's International Narcotics and Law Enforcement Program, and was previously Director of the Counterterrorism Bureau's Office of South and Central Asia and Near East Affairs. Chris, you have the floor for further opening remarks. Thank you.
Thomas, thank you. Thank you all for attending today's event. I'd also like to thank the International Institute for Justice for hosting, and also for the broader role they have played in our work to advance criminal justice approaches to counterterrorism. We're here today to discuss the state of our collective efforts on battlefield evidence. It is important at the outset to define what we mean when we use this term. We are referring to information or material collected by military forces and its potential use in civilian criminal justice proceedings. As we learned in the fight against ISIS in Iraq and Syria, battlefield evidence provides the international community with important tools to hold terrorists accountable for their crimes. Beyond that fight, the effort to bring evidence from the battlefield into the courtroom is at the forefront of our counterterrorism approach. I'll start today with some background on our work. At the State Department, we began focusing on battlefield evidence several years ago when we were hearing from our partners about their challenges prosecuting former foreign terrorist fighters who traveled to Iraq and Syria. Many expressed concern that military forces possessed valuable information that would help them make these cases against them. We agreed that it was necessary to ensure that the information collected by the United States and other militaries was being shared efficiently and in a manner that could be used by civilian prosecutors and law enforcement authorities around the world. For our part, as Thomas just noted, the United States launched a joint initiative between the Departments of State, Justice, and Defense, enabling us to make a number of changes to facilitate this sharing. This includes the Department of Defense declaring that raw information and objects collected by our military would be presumed unclassified. Also, as Thomas noted, we developed our 14 non-binding principles on battlefield evidence to reflect the U.S. government's views on the essential ingredients to battlefield evidence, which is available on the IIJ's website. Finally, we prioritize assisting our partners to increase their capabilities. Our partners in the broader international community have taken significant steps forward as well. Just to list a few of these, they include the UN Counter-Terrorism Committee Executive Directorate developing international guidelines, the European Union efforts to convene member states to identify best practices and gaps, and the Council of Europe is finalizing guidelines for its members. The Global Counterterrorism Forum developed and endorsed the Abuja recommendations on the collection, use, and sharing of evidence for purposes of criminal prosecution of terrorism suspects. NATO enacted its first ever battlefield evidence policy. The IIJ, through the Senior Leaders Seminar in December 2019, and the global and regional workshops for practitioners that they've hosted, has provided countries with a better understanding of this information. And finally, the European Union, the United States, and others have partnered with UN organizations, particularly UNODC, to assist countries in need of capacity building assistance. The focus on battlefield evidence and the importance of prosecution has yielded concrete results in prosecuting terrorism cases across Europe, Central Asia, and Africa. Denmark, Germany, Kosovo, Morocco, the Netherlands, North Macedonia, the United Kingdom, the United States, those are just some of the countries that have successfully used battlefield evidence in criminal prosecutions. While we can point to real progress and multiple successes, we still have a long way to go. There are major challenges remaining, ranging from deciphering and translating mass amounts of data, addressing legal and policy frameworks that pose artificial barriers, information stovepipes within governments, the lack of human and financial resources of some of our partners, and overcoming the misperceptions and misunderstandings on battlefield evidence. The bottom line is that in the years ahead, we will need stronger law enforcement cooperation to investigate, disrupt, and prosecute terrorist cells. We have seen that foreign terrorist fighters who do not face justice will lie in wait for their opportunity to strike again. They will travel to other countries and other conflicts, and they will continue to fight. As we will hear more from our other speakers today, battlefield evidence has become critical to success in this environment. Using battlefield evidence also sends a message to would-be terrorists. If someone chooses to travel to join a terrorist or violent extremist group with a hope that he or she might be able to return home to a normal life, they will be held accountable. We need to not only be capable of using battlefield evidence, we need to do it right and to be seen as doing it right. Being able to leverage the legitimacy of our justice systems requires developing appropriate legal frameworks and rules of evidence. Standardizing practices and procedures for the life cycle of battlefield evidence helps a great deal. Beginning before the first item is collected in the field, we need to ensure the integrity and accountability of our process and institutions, particularly regarding chain of custody and forensic analysis. This lends credibility to the evidence itself. Having sound legal frameworks and presenting credible evidence against criminal defendants in open court is how we prove not only that we can outfight terrorists, but that we do so in accordance with our democratic values. We make it more difficult for those who would criticize our efforts or promote a more authoritarian approach. We welcome the discussion today on battlefield evidence as we continue to improve the international community's ability to bring these individuals to justice. I'd like to once more thank you all for participating in this discussion, and then turn the floor back over to Thomas. Thank you.
Thank you, Chris, and thank you for the opening remarks, which really set very well the scene for the host of issues that I am sure the other speakers are going to mention, not the least the number of different initiatives that are being done, because this is such an important topic as we take the evidence forward in the post-conflict situations that we're in now. We will be hearing now from three distinguished speakers on the importance of this topic. And for everybody listening to these remarks, I would like to remind you that in the Zoom, there is a Q&A function. If you have some questions you'd like to please post them in the Zoom function. We'll take note of them and try to answer as many of them as possible, or get back to you later with our answers. Please try to keep your questions focused on topic, and we'll be able to get through as many as we can. Now, I'd like to first introduce Mr. Mark Lesko, Acting Assistant Attorney General for National Security, Department of Justice, United States of America. Acting Attorney General Lesko leads the Department of Justice efforts to address national security issues related to cybercrime, terrorism, and espionage, export control and sanction laws, authorities of the Foreign Intelligence Surveillance Act, and other national security review issues. Prior to this assignment, he served as the acting United States Attorney for the Eastern District of New York, where he was the Chief Federal Law Enforcement Officer for that district, and he also previously served as an Assistant United States Attorney for the District of Columbia. Mark, I give you the floor and look forward to your remarks.
Thank you, and can everybody hear me?
Yes.
Great. Thank you for inviting me to speak with you this morning. The National Security Division of the Department of Justice is responsible for the design, implementation, and support of law enforcement efforts, legislative initiatives, and policies and strategies related to combating international and domestic terrorism. In addition to the prosecution of terrorists in U.S. courts and our other national security-related work, NSD, in partnership with the State Department, engages in a wide array of international work related to countering terrorism. As a result, we are at the forefront of counter-terrorism cooperation and the U.S. effort to better utilize battlefield evidence. The global national security landscape is more complex than ever and poses challenges to all of our countries. Terrorist groups, of course, continue to pose a significant threat. Preventing terrorist attacks in all forms remains one of the top priorities for the U.S. Department of Justice. While we continue to face threats from violent extremists such as racially, ethnically motivated violent extremists, REMVs, international terrorist groups such as ISIS and Al-Qaeda remain a significant transnational threat to the United States and Europe. As FBI Director Wray has recently noted, ISIS and Al-Qaeda operatives continue to look for vulnerabilities and have not stopped trying to carry out large-scale attacks. I note that we are paying close attention to the evolving situation in Afghanistan. The horrific attack that ISIS-K carried out on August 26th, which killed 13 United States service members and numerous Afghan civilians, demonstrates the persistent and significant threat posed by terrorist groups inside Afghanistan. We must remain vigilant and continue to monitor such terrorist groups in Afghanistan, especially the potential reemergence of externally directed terrorist plotting. We risk the resurgence of terrorist violence worldwide if Afghanistan is allowed to become a training ground for terrorist groups such as Al-Qaeda and ISIS-K. It will therefore be important to work with international partners to ensure that, consistent with UN Security Council Resolution 2593, Afghan territory is not used to shelter or train terrorists or to plan or to finance terrorist acts. In addition to vetting issues, the immediate threat from the various terrorist groups currently located in Afghanistan, we also confront the risk of foreign terrorist fighters trying to move to and from Afghanistan. We have seen this phenomenon previously, of course, in Syria and Iraq. We must continue to use all the tools at our disposal to prevent the travel of foreign terrorist fighters, including the sharing of intelligence and law enforcement cooperation. Investigations and prosecutions, of course, require information and evidence to be effective. Information and evidence can come from a variety of sources, including documents and media collected from the battlefield. The United States recognizes the importance of effectively sharing information gathered on the battlefield to support criminal investigations and prosecutions of returning foreign terrorist fighters, and to mitigate the threat these fighters pose. This includes using the information for watch listing and border screening. Our prosecutors are ready to work with all of our partners to facilitate the sharing and use of battlefield evidence and to ensure that terrorists, including returning ISIS foreign terrorist fighters, no longer pose a threat. The United States shares battlefield evidence through Interpol, through the FBI legal attaches stationed in embassies around the world and through military and intelligence channels. We also share the information for watch listing purposes through our terrorist screening center. US law enforcement authorities also share with Europol. For instance, in 2019, we supplied 18,000 records derived from thousands of ISIS documents from 2015 to 2017 that were found in Iraq and Syria. The United States fully encourages our foreign partners to engage with their FBI legal attaches to discuss requests for searches of US holdings and databases for battlefield evidence and other relevant information. We continue to work with our military and with our international partners on ways we can enhance cooperation to overcome obstacles to sharing of battlefield evidence with our allies in a manner that may facilitate criminal investigations and prosecutions. Recognizing the challenges faced by the United States and our foreign partners, in 2018, the United States developed an interagency team of the Departments of Justice, State, and Defense to help enhance cooperation and collaboration in understanding and overcoming the challenges we face both as a nation and as an international community in sharing and using information obtained from the battlefield. That interagency team developed the United States non-binding guiding principles on the use of battlefield evidence. These principles have been widely shared and can be a starting point for the conversation between the military and law enforcement on how to collect, store, and use battlefield evidence. The guidelines are available in multiple languages on the website of the Institute for International Justice and the Rule of Law. In addition, the United States, including members of that interagency team from the Departments of Justice, State, and Defense, have been active participants in recent efforts by NATO and the Council of Europe to develop their own battlefield evidence policies. We also appreciate and have participated in prior efforts by the United Nations Counter-Terrorism Directorate and the Global Counter-Terrorism Forum to address this issue. The US guiding principles are merely that, suggested best practices regarding the collection, storage, and use of battlefield evidence in investigations and, where appropriate, criminal prosecutions. Countries must ensure that they have the appropriate legislative and evidentiary frameworks to allow for battlefield evidence to be used effectively for investigative and prosecutorial purposes. We all must recognize that such information can be, but often is not, the missing link enabling a prosecution. However, battlefield evidence can be extremely helpful as an investigative lead to develop additional information that may help bolster a prosecution. Battlefield evidence may also serve as additional evidence in a case that can justify a longer prison sentence for a particular defendant. In US terrorism prosecutions, US federal prosecutors have successfully used battlefield evidence over the course of many years. For example, in 2011, fingerprints found inside the components of an improvised explosive device recovered in Iraq in 2005 were matched to the subject of a terrorism investigation, Wad Ramadan Alwan, living in the state of Kentucky. Alwan, a former Al-Qaeda in Iraq member, was subsequently charged with the attempted use of a weapon of mass destruction, along with various other charges developed in the investigation. The fingerprint evidence from the IED was instrumental in the defendant's decision to plead guilty, and he was later sentenced to 40 years in prison. This case also highlights the importance of the storage of battlefield evidence, as the IED evidence did not become relevant in the United States investigation for more than 5 years after the IED was recovered on the battlefield. A more recent example from 2017 concerns a US citizen, Mohammed Jamal Qais, who traveled to Iraq to join ISIS. He was later captured in Iraq and returned to the United States for prosecution. Prior to the start of his trial, battlefield evidence was found and provided to the prosecutors, which included an ISIS intake form and also an ISIS camp roster. The evidence was successfully admitted at trial, and Qais was ultimately convicted and sentenced to 20 years in prison. The use of battlefield evidence to protect our countries is not a new challenge, and it is not one that will go away in the near future. We will continue to see challenges in watch listing and screening individuals who may have returned from being trained by and fighting with ISIS in Iraq, and the Syria battlefields. We continue to hope countries will repatriate and prosecute, using battlefield evidence, their fighters currently being held in Syrian Democratic Forces custody in Syria. We know that military and law enforcement partners around the world, such as in West Africa and the Sahel, East Africa, Southeast Asia, and elsewhere, continue to gather information that may be useful in stymieing terrorist threats emanating from those regions. We must continue to be vigilant and mindful of these threats and ensure that we take the lessons learned from our collective efforts in Iraq and Syria and apply them to new frontiers. Thank you.
Thank you, Mark. Thank you for those remarks. Of course, I'd also like to compliment the tremendous relationship we have with the Department of Justice here at the IIJ. It's a great partner for us. The prosecutorial examples you gave are quite elucidating, and also some of the partners you mentioned, such as Interpol and Europol, we've worked with great, and if we had more time in today's side event, we certainly would have such speakers as them as well. Now I'd like to introduce Dr. David Sharia, Director and the Chief of Branch for the United Nations Counterterrorism Executive Directorate. David, he leads a large group of international experts advising the Security Council on counterterrorism matters. Previously, he was with the Attorney General's Office of Israel. He acted as a lead attorney in major counterterrorism cases before the Supreme Court of Israel, and also chaired the Interministerial Counterterrorism Task Force and served as counterterrorism representative of the Attorney General to the Law and Constitution Committee of the Israel Knesset. He's published a number of academic articles and books, many of which I've had the pleasure of reading, and served as a scholar in residence at Columbia Law School and the New York University Center for Global Affairs. David is a great colleague and friend of the IIJ's. David, the floor is yours.
Thank you, Thomas, and many thanks to you and to your amazing team for organizing this event and for the wonderful partnership that CITED has with your organization. Thank you also to the US government for co-sponsoring this event and for the support you offer to CITED, including in particular in the context of developing the guidelines, the battlefield evidence guidelines, which I will share with you a few words on the process and development of which. Developing guidelines for battlefield evidence posed CITED with a great dilemma, one that does not offer simple, easy solutions. Do we want to encourage military units to replace civilian law enforcement? No, definitely no. Are we concerned, or were we concerned, that by developing battlefield evidence guidelines, we run the risk that military units will replace law enforcement and that abuse will occur? Yes. We were also very attuned in the process to these concerns when shared with us by our partners from the human rights community, who highlighted these potential risks. But there is also another side to this story. Can we bring terrorists to justice without this trove of information collected by the military? Probably not. Can we bring justice to victims without having law enforcement access to this information? Probably not. And a broader concern is that countries who are looking into possible repatriation want to make sure that they're not bringing people who will commit further crimes in their countries and that will face justice on the crimes they have committed. Those countries will not accept immunity and want to see people paying the price for mass murders, rape, terrorism, and other international crimes. The Security Council has regularly emphasized that those responsible for terrorist acts and violation of international humanitarian law or violations or abuses of human rights in terrorist context must be held accountable. So we were facing a big dilemma, one that one of the most prominent American jurists, Guido Calabresi, called tragic choice, where you don't have a good solution, but you have to choose among two less than ideal solutions. And this is what brought CITED in 2014 to begin the challenging task of developing the battlefield evidence guidelines. The year was 2014, when ISIL was controlling large parts of Iraq and Syria, allowing it not only to commit heinous acts of violence against civilians, but also to plan and perpetrate attacks across the world. We met with prosecutors all over the world, including in 2 meetings, one in Tunisia and another one in The Hague, sponsored by our dear partners from the EU Coordinator's Office, and I'm glad that they are joining us today. We knew some of them have committed, some of those terrorists have committed heinous crimes, and that prosecutors around the world need support and guidance in prosecuting them. And this is the key, while respecting the rule of law, which in this case, including human rights law and international humanitarian law. We are very proud that we met this challenge and that CITED was the first international agency to tackle this difficult challenge. We are thankful to the many IROs and governments that supported us in the process, including in particular the host country of this meeting, the US government. We are also very thankful to our partner in crime, the United Nations Office of Drugs and Crime, under the able leadership of Masoud Kaminpour, who will speak shortly after us on the TID programs his office is leading following our joint efforts to develop the guidelines. We are also, much like our previous speaker, proud to see that 7 years after we brought this issue to the center of international attention, many other partners are looking into developing their own challenges, their own guidelines. We are also very proud to see that Resolution 2395 identifies the challenge and calls member states to develop guidelines and solutions to this challenge. We are very pleased also because from the outset, we made it clear that this is a first attempt and that we hope that the development of the guidelines will trigger others to develop best practices and guidelines. And indeed, since we embarked on this process, we could have seen that the EU, the Council of Europe, the GCTF, NATO, and the ICRC are developing their own guidelines, and all of them are ready for use, or about to become ready for the use of practitioners. So what do the guidelines include? First, they are non-binding tools. They are based on a variety of sources, including international law norms and standards and practices of some member states. They recognize relevant obligations under various sources of international law, but they do not themselves impose obligations on states. Second, although the FTF phenomena was the impetus for the development of this document, its applicability goes well beyond Iraq, Syria, and FTFs. The best way to use these guidelines is as a basis for discussion within a member state or IRO, and to illustrate the issue that will need to be comprehensively addressed at the national level by those national authorities responsible for determining and enforcing the criteria for the admissibility of evidence in national criminal proceedings. These guidelines are truly a living document. The core of the guidelines, as I stressed before, is identification of rule of law principles relevant to the collection, preservation, and use of such evidence, and apply them to the context of battlefield evidence. The guidelines highlight good practices relating to setting up a national legal framework, allowing the military to assist in the collection of information that could be used in civilian criminal justice proceedings. The guidelines also recommend that any framework relevant to the collection of battlefield evidence incorporates adequate safeguards, including independent periodical review, a fundamental matter for any member state. They provide guidance related to the establishment of mechanisms to promote interagency communication, cooperation, and coordination, and for the sharing of information multilaterally and bilaterally. Importantly, they highlight the importance of compliance with international human rights law and international humanitarian law. They stress the need for respect for internationally recognized fair trial principles and standards, but also matters related to the rights of victims and witness protection, in particular, vulnerable witnesses such as victims of rape and sexual violence committed with a terrorist intent, children, including child soldiers, and the elderly or disabled. CITED and UNODC are ready to support any member states or IRO in the process. We are very conscious of the human rights and IHL concerns and challenges associated with the development or implementations of this guideline, and we hope to be able to provide any assistance to member states interested in developing such capacity. Let me thank again you, Tom, for your wonderful partnership with CITED, and to the IIJ for organizing this event, and to the US for supporting our work in this context. Thank you very much.
Thank you, David, particularly for that great overview of the UN guidelines, which of course we are integrating into our own work, and we look forward, as we've already had some discussions with you, about continuing our partnership with CITED and the work that we're doing on this very important issue. Now I'd like to introduce our last speaker, Dr. Shada Emek. Dr. Emek is an advisor to the European Counter-Terrorism Coordinator. Previously, she was a German administrative judge and also served as the clerk for the German Constitutional Court and at the German Federal Ministry of the Interior. She holds a doctorate in international law studies and has worked at different international universities on human rights law and is a frequent partner with the IIJ. It's good to see you again on this side event virtually. And Shada, the floor is yours.
Thank you very much. Thank you very much for the IIJ for organizing this really important event. The European Union supports its member states in their commitment to address the foreign terrorist fighters phenomenon as requested by the UN Security Council resolutions. And for this, the heads of states and governments tasked the EU in June 2017 to accelerate collective efforts to share knowledge on foreign terrorist fighters, but also to put forward policies and legal measures to manage the threat. In addition to this tasking by the heads of states and governments, the Joint Home Affairs and Defense Council encouraged specifically EU institutions in May 2017 to work especially on battlefield information in this framework. And following all this tasking, the EU has adopted new legislation on counterterrorism 2017, especially the EU Counter-Terrorism Directive, to be named here. The directive aims to prevent suspected foreign terrorist fighters to enter or transit EU territory, to criminalize travel from and to the conflict zones, or to undergo combat training with the aim to participate in an international terrorist organization. On the policy side, the office I'm representing today, the EU Counterterrorism Coordinator, suggested a series of policy measures to strengthen the sharing and use of battlefield information in the European Union. We did this for the first time in September 2017, and we are constantly reviewing the EU's work in this field. And I can state that much progress has been achieved on battlefield information since we started in 2017. Let me give you an overview of what we've done, what we've achieved. Europol, the EU law enforcement agency, cross-checks police databases and provides feedback on existing battlefield data that matches queries. Europol has also established a terrorist identification task force. This task force convenes CT analysts of EU member states and selected partner states. And Europol has established an analysis project on core international crimes to assist member states on these cases. On the justice side, Eurojust, the European Agency for Criminal Justice Cooperation, is supporting EU member states. Eurojust has carried out a mapping on the use of battlefield information by judicial authorities in the EU on our request. And it has issued a first report that is called the Memorandum on Battlefield Information in 2018. In 2018, according to this report, information from the battlefield battlefield had been deemed admissible in courts of various member states. In fact, from the legal perspective, there were no specific restrictions in the legal systems of most member states for the use of battlefield information, or battlefield evidence in that case. The main requirement remained, and that was the admission of evidence that was not obtained by criminal act or in a manner that violated human rights. But the outcome of the report was also that judicial authorities often simply lacked access to evidence coming from the battlefield to use it as proof in criminal proceedings. For that reason, convictions in the European Union could often only secured only for membership or participation in a terrorist organization, but not really for the actual crime committed. Eurojust has updated this report in September 2020, again on our recommendation, and we see now that there has been significant progress in the EU with regard to the use of battlefield information in judicial proceedings. There is better access to battlefield information, but also judicial authorities are much more familiar with the use and admissibility of such evidence. Prosecutors in the European Union have also increasingly started to secure convictions of foreign terrorist fighters and their affiliates based on cumulative charges. This means prosecutions based on international crimes such as war crimes or the crime of genocide, as well as terrorism charges in parallel. Eurojust and the EU Genocide Network at Eurojust have become a hub of expertise for such prosecution strategies. This is where our prosecutors meet and share their best practices, but also convene on cases in joint investigative teams in cross-border cases. Last but not least, on the judicial side, let me mention the European Judicial Counter-Terrorism Register, which we established in 2019, that is also hosted by Eurojust. The register enables early detection of possible links between ongoing cross-border investigations by national authorities. Again, a cross-border cooperation among prosecutors in the European Union. The final area I will mention here, where we made recommendations on the policy side, is the strengthening of international cooperation and international engagement of the European Union, also with regard to capacity building. We have been engaging with the US government bilaterally on battlefield evidence since 2017. Our office, the European Counter-Terrorism Coordinator, together with the European Commission, have organized in close cooperation with the US government, for example, a high-level workshop in Brussels in 2019 to learn from each other on the use of battlefield evidence in the various policy fields mentioned. The European Union is also engaging on relevant global fora on foreign terrorist fighters and battlefield information. The Global Coalition Against ISIS, G7, GCTF, Interpol, Council of Europe, you name it. We are present and we try to engage in all these areas on behalf of our member states and support of member states. We've also contributed, as was mentioned by David, to the UNCTAD guidelines, and we've contributed to the GCTF Abuja recommendations, and we support them strongly. With regard to the capacity building, we stepped up. The European Commission has financed a project for Iraqi military and law enforcement to collect battlefield information. This project was financed by the Commission, managed by Interpol, and conducted in a NATO excellence site, Center of Excellence in Vicenza, Italy, for example. The European Commission currently finances and supports UNITAD in Iraq on a project for the scanning and indexing of ISIS-related documents held by Iraqi authorities that can be used in criminal court procedures in Europe and elsewhere. It is also financially supporting IIIM for Syria, with which our member states engage closely. And last but not least, the European Commission is supporting rule of law-based capacity building projects for law enforcement, as well as judicial authorities and security sector reform in Iraq, the Middle East, and North Africa, so the MENA region and Sahel countries. And we see this in the broader the context of battlefield evidence and rule of law-based battlefield evidence introduction to courts. While I will wrap up now, let me stress one last point because it is important for us at this very moment, and it was mentioned by at least one speaker before me. Let me stress the importance of the sharing of battlefield information in the context of the situation we are currently facing with regard to Afghanistan, and particularly for security checks at external borders and with regard to the evacuees from Afghanistan. We are working on better use of battlefield information in border security databases in the European Union, and we believe there is a strong need for the international community to come together on this with regard to Afghanistan at this very moment. I will leave it here. Thank you very much.
Thank you, Shada, for those remarks, and of course, for all the work that's being done in the European Union through your office of the Counter-Terrorism Coordinator, but also, as you mentioned, Europol, Eurojust, the Commission's work. These are all valued partners that we're working with now. I was particularly heartened to hear that the work that's gone on the last few years has actually raised the understanding and use of battlefield evidence into prosecutions in the European Union space, which is, of course, one of the efforts that we're trying to promote through these guidelines and other efforts going on. I also thank Mark and David for your remarks. We're right on schedule, so I am going to now pass the baton to Hop Wells, our other moderator, and he has some Q&A questions that he will pose to our first sets of speakers. We have about 10 minutes on the schedule remaining, and then we'll shift to the remainder of the speakers. So Hop, I pass the floor to you.
Thanks very much, Tom, and thank you to all three speakers. I'm following all these submissions through the Q&A here on Zoom. A lot of really good questions. Some are kind of broader, some are more specific. I'd like to synthesize some of these and ask a broader question about priorities and pose that question to each of the three speakers. And we heard from you all about a lot of progress made in terms of collection, coordination, clear guidelines, improving access to this evidence across borders, but also some areas where work is still to be done. And some of these changes are larger, long-term, really making investments toward a future where we can use this evidence better to bring accountability for grave crimes, not just in Iraq and Syria, but in many conflict areas. And at the same time, we heard about why this is not just an important challenge, but also an urgent one, both to international security more broadly, and also sometimes in specific cases. You need to get the evidence to the courtroom in time for it to be useful in that case. So I'd like to break that apart, the important and the urgent. What is the challenge or the gap, or what is a challenge or gap that's really time sensitive and really kind of urgently needs improvement from your point of view? And what's a challenge or gap that is going to take time and will need longer term investment and readjustment, but is important enough to warrant that? Yeah, I'll give this one to Dr. Sharia. David, why don't I go to you first, and then I'll give the other two speakers a chance.
Thank you. I would say my response on behalf of CIDED would be short in this regard. Our guidance are not operational. Even though many of us in CIDED have operational experience, including in this area, we felt that there are other partners, and many of them were already mentioned here in this conversation, that are much better suited to develop operational guidance or to guide teams and units on how to develop their own guidelines or protocols to meet this challenge. The focus of the guidelines that we were developing was on rule of law principles relating to the collection, preservation, and use of evidence, as well as some principles relating to issues like chain of custody, issues like coordination and cooperation among civilian and military units, and issues relating, of course, to international law, IHL, etc. So this is what the UN is best in offering, when others can bring operational advice from their own experience, as they've done in the case of the US guidelines or the case of NATO and others. Thank you.
Thanks very much, David. Why don't I go to Acting AAG Lesko next? Mark, I'll give you a chance to weigh in on both kind of a really urgent challenge, it's time sensitive, as well as a longer term challenge that's important enough to warrant the investment.
Thank you. I think the near-term challenge that is pressing is the landscape in terms of countries that may not have proper legislation or evidentiary rules in place that allow for the full use of battlefield evidence. I mean, we can only go so far in terms of sharing the evidence, potentially making witnesses available for the authentication of the evidence and to establish chain of custody. But if you're not allowed to use the evidence to begin with in a particular prosecution in a particular country, that's an insurmountable hurdle. So that is, I think, the most pressing issue. I would echo some of the sentiments that have been raised by my colleagues in terms of long-term. I think we need to continue to work in terms of making database improvements, improving the process for sharing the evidence, including improving the storage of the evidence, the collection itself, the process related to exploiting the evidence. All of that can be improved, and we are working on improving it. We do have a existing community of interest led by our National Counter-Terrorism Center, and that community is working on all of these issues. But again, I'll circle back to the most pressing issue, which is instances where a willing country who is interested in obtaining battlefield evidence to prosecute a terrorist, for example, and they simply just can't use the evidence affirmatively in their cases. And I think that is the most pressing, most concerning issue.
Thanks very much, Mark. Finally, I'll give the same opportunity to Shada. You have the floor.
Thank you, Rob. I would say the most pressing and most urgent field to work on at the moment, nationally, but also internationally, or region-wise and internationally, is really the sharing of biometrics, especially for border security purposes, because there's a lot to step up with regard to the technical aspects of being able to insert biometrics in law enforcement and border security databases. So there's a technical component, but there's also a cultural component to make intelligence agencies insert data in databases of other units of other organizations and share it with them and share it internationally. I think that is especially because we are seeing a lot more interaction internationally and terrorist travel or people travel. That is, I would say, the most pressing issue. Of course, also with regard to the current situation. I mean, we had the situation already back in 2019 with regard to northeast Syria, the US withdrawal from northeast Syria, the Turkish incursion to northeast Syria, and we are facing it now with regard to Afghanistan. More longer term, I would say, from an operational point of view, and if I speak to practitioners, it's really the structured and systematic exchange within governments on battlefield information. And that often it is just on an ad hoc basis, but there is no established procedure. There's very few countries like the US or France who have a structured and systematic process going on within the government as a whole government approach on the sharing and communication on battlefield information. And another point with regard to longer term, I would say, is really cooperation with NGOs present in the conflict zones. There is a long-standing cooperation going on with law enforcement or with other agencies governmental agencies with regard to migration and refugees, maybe, but it is not necessarily the case with regard to counterterrorism. And that is something where I think we need to work on to understand how the different entities work and to have some familiarity also. And to also be able to have evidence or interviews, for example, conducted by NGOs in the conflict zones that are later on reliable and based on rule of law principles, which they may not be aware because they're not lawyers, they are doing other things. And then the prosecutors in the countries that whether interviews or the evidence is shared with, they have necessity. So that would be my second point. Thanks.
Great, and thank each of you for those thoughtful comments. I think that gives all of us a sense of the range of different challenges that are involved here, and really the need to keep pushing in a lot of different areas, both as individual countries and at the national level, but internationally and multilaterally too. I do want to keep us on schedule, so with that, thanks again, and I'm going to move to our second panel as we have 4 more distinguished speakers who will discuss some recent advances in a kind of concrete level in how battlefield evidence is collected, exploited, shared across borders, and used in court, and identify some more improvements needed to address any challenges that they've seen in their experience. The first speaker on this panel will be Mr. Masoud Karimipour, Chief of the Terrorism Prevention Branch in the United Nations Office on Drugs and Crime. He has been a trial attorney, criminal justice policy advisor, and rule of law development manager for 33 years. He served as a UNODC strategic coordination advisor and is UNODC regional representative first in Central Asia and also in the Middle East and North Africa, as well as in the UN peacekeeping mission in Sudan and in Afghanistan as the chief of the Afghanistan Justice Sector Support Program. Masoud, very glad to have you with us. You have the floor.
Thank you, Hop, and good morning and good afternoon. First, let me thank IAJ and the U.S. State Department's Bureau of Counterterrorism for inviting UNODC to contribute to this important event. I'm happy to share with you some information and analysis about the important role of battlefield evidence or military evidence in establishing accountability for terrorist offenses in conflict zones. Tom Buchte, Chris Landberg, Mark Lesko, David Sharia, and Shada Emek have already covered a lot of real estate, so it's going to be hard for me not to repeat anything they've said, but I will try, and apologies in advance if I do. Just a quick situation analysis. We've witnessed, unfortunately, that West Africa and the Sahel region continue to suffer recurring complex terrorist attacks on civilians and defense and security forces, as well as forced recruitment and abductions, in particular in Burkina Faso, Mali, Niger, and Nigeria. We've also seen violent extremists and terrorists exploiting the COVID-19 pandemic to advance the radicalization, propaganda, and recruitment, and taking advantage of the perception that the security apparatus attention is diverted elsewhere, and in many places they were. Nevertheless, member states in these regions are being supported by international partners and the UN to continue to fight terrorism and to bring to justice perpetrators and organizers and sponsors and financiers. Of course, this has to be done in compliance with the rule of law and international human rights and humanitarian law obligations. But let's be clear, bringing terrorists to justice and holding them accountable for terrorist offenses is an international legal obligation. Security Council resolutions and General Assembly resolutions make those clear now. But member states face challenges in achieving this goal, and in situations where civilian law enforcement and judicial officials are not able to be the first responders, such as in conflict zones, this creates a huge problem. And so when military forces do become first responders, it's important to recognize that they lack the capacity and the information needed to know, to recognize evidence, to be able to preserve it, to ensure its integrity and chain of custody, so that judicial authorities can actually use them. So we have here a challenge that we, as the international community, have taken on. And I should also add that information gleaned from conflict zones not only can provide the basis for prosecution on individuals, but can also prevent other terrorist attacks from happening if that information is properly retrieved and analyzed. This information includes data about identity of individuals, whether they're there physically, whether they're detained or not, and membership of individuals in organizations, biometric information, and other information related to terrorist group command, control, structure, weapons, finances, etc. So in practice, cases against suspected terrorists that are built on battlefield evidence may not meet the required legal and evidentiary threshold for referral to court, let alone successful convictions. And where the threshold is met, it's often not sufficient for prosecution for significant offenses, and prosecution for relatively minor offenses result in relatively short custodial sentences and the release of highly radicalized or trained terrorists who then are able to travel. And this lack of admissible evidence has also resulted in unjustified prolongment of pretrial detention of individuals against whom there is no evidence. And sometimes even their identity is not known to the military who rounded up a group of people. And so this presents, of course, due process challenges for the judiciary, detainees themselves, and of course, the cause of peace in the community and political stability in the country. And this same evidentiary problem has made several countries reluctant to repatriate their nationals from conflict zones due to lack of sufficient evidence collected from conflict zones. So here's a quick analysis of the gaps that result in the inability to collect admissible evidence from battlefields. First, weak interagency coordination among military units and other criminal justice and law enforcement officials, as Shada just referred to. Absence of standard operating procedures defining the detailed steps to be followed by the military. Lack of clarity about the legal capacity as prescribed by the national criminal procedure codes for the military to conduct this role. And I think we had that already identified as a priority for the US to help countries strengthen their legal framework to do just that. Unfamiliarity of the military with basic legal and technical requirements to collect and preserve information. Difficulties in obtaining battlefield evidence through international judicial cooperation and mutual legal assistance channels due to the differences in legal systems and standards. So let me quickly now turn to the technical assistance that UNODC has developed through a package of specialized technical assistance to meet these needs at the strategic and operational levels. First, at the strategic level, UNODC and CTED, or as David put it, our partner in crime, have collaborated on producing the guidelines on military evidence. These guidelines serve as a comprehensive document that help member states develop their own national policies and action plans to address these issues. And of course, already we've had the reference made to other such strategic documents, such as GCTF's Abuja recommendations and the Council of Europe's recommendations, etc. At the operational level, we are in partnership with several partners, such as the governments of Belgium, Germany, Italy, the European Union, and the United States through the Department of State's Bureau of Counter-Terrorism, and have developed specialized technical assistance programs for the benefit of countries in West Africa, including Burkina Faso, Mali, Niger, Nigeria, and also the police component of the G5 Sahel Joint Force. Some of the examples of the achievements under these projects are in Niger, enhancing strategic coordination and interagency cooperation. In Niger, we have, in partnership with the US CT Bureau, supported the development of an MOU between Ministries of Defense, Interior, and Justice for enhancing interagency coordination on the collection of battlefield evidence. among those entities. The MOU was signed in 2019. In Burkina Faso, we have, in partnership with the governments of Belgium and Italy, also facilitated the development of an MOU between the Ministries of Defense, Justice, and Security that was signed on 9 September of just this month. And now at the on the front where we have enhancing cooperation at the operational level to get actors on the ground to cooperate and to streamline the practices performed by the different actors and ensure their compliance with legal standards. We've supported the national counterparts in Burkina Faso and Niger to develop standard operating procedures on the collection, preservation, and sharing of battlefield evidence. On a different front, building a specialized task force to collect battlefield evidence. We've supported the preparation of a task force of quote unquote military evidence officers who receive training on legal and technical aspects related to the collection of evidence during CT operations, and also the provision of necessary evidence kits that allow performing this task in conformity with evidentiary chain of custody requirements. Let me conclude with a few words about the way forward. Of course, as the engagement of the military in counterterrorism operations in West Africa and Sahel continue, our efforts to support accountability for terrorism crimes must also continue. So we would recommend countries in West Africa and the Sahel be provided with technical assistance tailored to their individual needs and gaps, such as by supporting the specialized investigative units, such as the gendarmes and specialized counterterrorism investigation units, to become more mobile and to more quickly deploy to conflict zones and to work more closely with military operations. Also by developing and operationalizing standard operating procedures that address all practices on the ground followed by the military and the criminal justice actors. Also by designating and preparing specialized task forces who could handle and supervise the process of collecting and preserving and sharing of the battlefield evidence. And finally, by enhancing the sharing of battlefield evidence through international cooperation and mutual legal assistance. Let me stop here not to abuse my allotted time, but also to allow time for questions and answers. Thanks again to the IIJ and the State Department CT Bureau. Thank you.
I will go next to our next speaker is Mr. Afram Shefkew. He is a senior prosecutor experienced in various criminal cases, especially in counterterrorism, currently state prosecutor in the Special Prosecution Office of the Republic of Kosovo, as well as head of the Counterterrorism Department there. He has previously been the acting chief prosecutor of Special Prosecution in Kosovo. Since 2000, he's worked in its justice system in various roles, including at one point and has participated, in several international conferences and trainings, particularly related to the repatriation of foreign terrorist fighters. Afram, you have the floor. I'm going to go to our next speaker, Mr. Saibu Maiga Alzuma. Mr. Alzuma has been General Prosecutor of the Specialized Counterterrorism and Transnational Organized Crime Judicial Unit at the Prosecution Office of the Appeals Court of Niamey in Niger since 2015. Since 2013, he has been also a Deputy Government Commissioner for Niger's Military Court, as well as Niger's acting focal point for the Sahel Judicial Cooperation Platform. Mr. Alzuma, you have the floor.
So first of all, I would like to express my thanks to the International Institute for Justice and the Rule of Law for giving me the opportunity to speak to you about our actions in Niger. The phenomenon of terrorism is very complex, and the view I will take is that of a prosecutor and so a prosecuting authority. Niger has had specialized counter-terrorism unit and chambers with national jurisdiction since 2011. It has been working with Barkhane since his arrival in 2014 and began given decisions on on cases in 2017. The suppression of terrorism in Niger involves the implementation and conduct of judicial proceedings applying the general rules of the Code of Criminal Procedure and special rules specific to terrorism in order to ensure the respect of procedural guarantees in accordance with the rule of law. The objective is to provide a judicial response to each case on a national level and to contribute on a sub-regional and international level to the fight against terrorism. In the framework of the repression of terrorism, the phase of research and exploitation of the evidence is the most tedious. And this is the subject of my presentation. I therefore want to present the case of the public ministry against Regradi Mohammad, judged in March 2017. So I will talk about the facts, the procedure, the means of evidence developed before analyzing the obstacles to the gathering of the evidence and the solutions put in place in my country. So in November, on the 16th of November 2014, Niger's intelligence service made available to the Central Service for the Fight Against Terrorism 8 people arrested by the French Barkhane Force during the military operations conducted during the night of the 9th and 10th of October 2014 at the Niger-Algeria border. These air and ground operations by the Barkhane Force were aimed at neutralizing a convoy of 6 pickup vehicles belonging to terrorist groups. On board this convoy, 18 individuals carrying nearly 2 tons of heavy weaponry, portable missiles, heavy machine guns, cannons, rifles, grenades, ammunition, and explosives, which were seized. The Barkhane Forces Provost Marshal, a gendarmerie responsible, a detachment of the gendarmerie responsible for following troops on the move to observe infractions, also transmitted a detailed report of these arrests, an inventory listing all the items that were seized, and several elements of evidence. So telephones, IDs, weapons, etc. These documents, which are essential for any judicial investigations, were drawn up by the provost marshals accompanying the elements of the Barkhane Force. So this is so now I will give a few words on the procedure. During the investigation, some of the defendants acknowledged their links with Hakim and assumed their intention to send this arsenal to the Mujahideen in Mali. On the 24th of November 2014, 8 days after they were handed over to the judicial services, the specialized prosecutor requests the opening of a judicial investigation for support and supply of weapons and explosives with the intention of committing terrorist acts, illegal possession of weapons, ammunition and explosives, and association of criminals in relation to a terrorist enterprise. 7 months later, the Dean of Investigating Judges closed the case and transmitted it to the General Prosecutor's Office of the Court of Appeal of Niamey. On the 24th of September 2015, the International Criminal Court requested from Niger authorities the surrender of one of the accused person, Hamad El-Faki, known as Abu Turad, to answer for crimes against humanity. Long before his surrender to the ICC, he had formally acknowledged that he was number 2 in the Ansar Dine group in charge of implementing Sharia law. He was tried in absentia in Niger for the facts. So on the 1st of October 2015, as Attorney General, I took requisitions to refer the case to the Chamber of Control of the Investigation for confirmation of charges and verify the entire procedure. On the 12th of February 2016, this chamber confirmed the charges and referred the accused to the trial chamber. On the 22nd of March 2017, after 2 years of proceedings, the trial chamber specialized in counter-terrorism pronounced acquittals and convictions and sentenced to 2 to 15 years of prison, fines up to 1,500 euros, and confiscation of military equipment seized for the benefit of the Central Service for Combating Terrorism.
Quels ont été les moyens de preuve développés à l'audience? D'abord, il faut comprendre que cette procédure est proactive, car les mis en cause sont interpellés à titre préventif avant la survenance d'attaques terroristes. Elles se font donc sur de nombreux éléments.
It's a proactive approach, and the analysis of the sealed evidences was very important, and the data that we got from their phones, and we got also information from the weapons used, the weapons that were used, and the explosive devices also used during the attack. So support and supply of weapons and explosives with the intention of committing terrorist acts could be used to open a judicial investigation. What are the obstacles to collecting the evidences? There are many obstacles. First of all, it depends on the judicial teams. You know, the judicial system is encountering many hurdles and difficulties. In most provinces, the people that are arrested.
We're getting very close to the end of the time, but I think we may have restored the connection. So I'd like to go back quickly to Mr. Alzuma, because I know you had a summing up that you wanted to give of some of the solutions that you see to the challenges that you've exemplified. So to Mr. Alzuma, you have the floor once again.
So we've learned from a lot of failures here in Niger. So first of all, we need to train the panel chain and the international cooperation. That's why capacity building training is very important. That it will have an impact on the field. So we have many programs, capacity building programs. And we need also sensitization. We do it in consultation with the military, and there are the documents that will lead to opening prosecution. These documents are essential for any judicial investigation. They are drawn up by the provost, accompanying the elements of the force. And during the investigation, Niger has worked a lot on many issues related to the rule of law. Thank you very much for the time you gave me. Thank you for your attention.
With that, I think we will, by hook or by crook, be able to stay on schedule then. Thank you to all of our speakers who made great efforts to prepare as well as to connect for this. And now quickly to close, pass the floor back to IAJ Executive Secretary Tom Wukti.
I'd like to again thank the U.S. Department of State's Bureau of Counterterrorism for supporting the event. And going forward, I'd just like to say on behalf, as is also said for many of our speakers, we'll be continuing to work on this topic both on a regional basis, following up such as we did with our West Africa regional workshop, and more focused on national basis, similar to one that we did with Tunisia on a bilateral setting. But we continue to think sharing of battlefield evidence is extremely important. It's one of the issues that the IIJ will take forward in 2022 with partners such as UNODC, CTAD, Germany, et cetera, and our colleagues at the Department of Justice. So thank you very much. I thank everybody again for this. Please be safe, and we'll be in touch. Goodbye.